What is the guarantee that this foreigner will not grant further access to other unauthorized persons to commit all manner of mischiefs? But more important, Madam Chief Justice and the honorable members, is the complaint by Justice Nyang'aya that Gudino Omar was uploading and downloading forms. There is silence with regards to that issue. Then there was the contention that other unauthorized IEBC staff also had access to the server. And their names were provided, Madam Chief Justice and the honorable members. In the replying affidavit by Hilda Kavonga, again they make this admission, and with respect to one Abdidahir Maalim, it is argued, and I'm referring the court to paragraph 13, Roman 6 of Hilda's affidavit. She says, Abdidahir Maalim was a returning officer, and this access was limited to transmitting Form 34Bs and not to any other function. Madam Chief Justice and the honorable members, the list of all the returning officers, who participated are included in the affidavit of Juliana Cherera, and specifically marked as Annex J C2. Unfortunately, the name of Abdidahir Mohammed does not appear. It is not indicated with respect to which constituency or which county he was the returning officer. It would appear clearly that there was a lie. Beyond that, the logs that were filed by Justice Nyang'aya were also analyzed by a forensic analyst, George Njoroge, and he submitted an affidavit to which he annexed a report. And in that report, Madam Chief Justice and the honorable members, it is clarified that Abdidahir Mohammed accessed the server more than 1,000 times. The question one would ask is, why would he access the server so many times? What was he doing? Madam Chief Justice and the honorable members, it is quite clear that the server was defiled. The next issue I would wish to speak to, and I can see I'm having serious time issues, is whether the IEBC verified the results. And it is my submissions that that did not happen. And I'm saying so for two reasons. First, and this is important because it's not been captured by my colleagues, according to the Constitution, it is not only verification by IEBC that is required. Verification is supposed to happen at two levels. First, by IEBC, but secondly, by Kenyans. That's why both Article 86 and Article 81E institutionalize transparency. IEBC should make sure that every processes that they are undertaking are laid bare for the public to see, so that the public can also follow the processes and undertake their own verification. For reasons that have already been explained, it is clear that this verification by the public was not possible. due to the opacity that has been referred to by my learned colleague, Apollo Mboya. But then there is the issue of verification by Iebc, which also did not happen and could not happen given the circumstances of this matter. Madam Chief Justice and honorable members, you have been told how 4 Iebc commissioners were sidelined in the entire process. It is our submissions that it could not have been the intention of Kenyans that Iebc commissioners be reduced to spectators in a presidential contest. That is something which is inconceivable, and we would humbly urge this court to put a stop to this practice. There are other issues that I would have wished to deal with, but because of time, allow me to cede the floor to my colleague, Jeremy. Thank you very much.
Yes, my Lady the Chief Justice and the honorable members of the court, my name is Gordon Ogola, and I'm representing the 6th respondent, that is Irene Masit. My Lord, I'll rush through my submissions because I don't want to give more time to my brothers. I've been sent here by the 6th respondent to tell the court and the whole world that she's not coming here as a second-tier petitioner. She's not coming here as a surrogate of anybody, but she's coming here as a demonstration of her undertaking to protect, uphold, and defend the integrity of the Constitution. Indeed, while taking oath of office, she undertook to carry out her duties in compliance with the Constitution. In that regard, the 6th respondent was alive to the fact that in conducting the general elections, they had to be guided by the provisions of not only Article 81, 86, and 138, but also Article 10 of the Constitution. My Lord, the 6th respondent submits that the manner in which the election process was managed by the 4th respondent, up to and including the tallying, verification, and the declaration of the results, flies in the face of the provisions of the articles that I've cited. As will be seen in the affidavit of Irene Masit and corroborated with the affidavits of the other form commissioners, the chairperson excluded the majority of the commissioners from the tallying and the verification process. In fact, if you go through the affidavits, you will note that the only duty that they were assigned or that they undertook as regards verification and tallying was when they were summoned by the chairperson to be given the results in the office. My Lord, and the other thing that they only did is after he told them, this is the results I'm going to read, was to give them the Form 34C. They did not take part in the tabulation of what resulted in Form 34C. My Lord, the 6th respondent had a legitimate expectation that as stipulated under 138(3)(c, that the tallying and the verification ought to have been done by the commission and not by an individual commissioner in the person of Chebukati. In fact, the exclusion of these commissioners did not start at that point while they were in Bomas, but it started at the point when he, Mr. Chebukati, unilaterally reassigned them duties that they would take at the floor of Bomas, which were completely at variance with the duties that they were holding as in the subcommittees that were running at the commission. My Lord, before the declaration of the results, the commissioners were expected to ascertain and satisfy themselves that whatever was being put into 34C was a true reflection of the contents of 34A and 34B, but they were never given that opportunity. My clients and the 3 commissioners have confirmed that they were not involved in the process at all that gave birth to 34C. My Lords, even during the declaration of the results done by the 4 commissioners, evidence that can be found in the affidavits shows that the only things they were given were handwritten pieces of paper with results in them. Those documents that they were given and which they were reading out to the public are not part of any accountable documents that can even be brought to this honorable court. Secondly, at the time of the declaration, my Lord, you will note that there were 27 constituencies whose results had not been verified. Even though the chairperson claims that they could not announce or declare the results of those 24